Welcome to VLearn Virtual Learning Network. This is session number 10 of Company Law and the topic is Membership in a Company. Topics to be covered are Member, distinction between members and shareholder, who can become member, modes of becoming a member, termination of membership, rights of member, liability of members, transfer of shares, distinction between transfer and transmission, register of members. Now come to the first topic, that is member. According to section 41 of the Companies Act 1956, a member means the subscriber of the memorandum of association of the companies. वो memorandum of associations के subscriber every other person who agrees in writing to become a member of a company and whose name is entered in its register of members. Those persons are called members. A person who puts his signature on the memorandum as a subscriber becomes a member before any share are allotted to him. In other case, a written application for the allotment of shares is necessary before the name of the person can be entered as a member in the register of members. The real test of membership is whether the name of a person appears on the company's register of members. If his name appears on the register of members, then only can he be treated as a member of the company, otherwise not. Distinction between member and shareholders. A company limited by guarantee having no share capital will have only members but no shareholders. When a person transfers his shares, he ceases to be a holder of those shares but continues to be the member of the company until his name replaced by the name of the transferee. The legal representatives of the decreased member becomes shareholders immediately on the death of the member, but they do not become members until their names are entered in the register of the members. Who can become members? First one is minor. According to section 11 of Indian Contract Act, a minor is incompetent to contract. Therefore, he cannot become a member of the company. Second, company. A company being a legal person is competent to contract. Therefore, a company may become a member of another company if it is authorized by its memorandum of articles. However, a subsidiary company cannot become a member of its holding company. Partnership firms. A partnership firm is not a legal person. जो partnership firm होती है वो एक legal person नहीं होती and it cannot buy share in its own name और वो अपने नाम पे shares नहीं buy कर सकती. A firm may hold shares in the name of individual partners who may be entered as a joint holder in the register of members. However, it can become member of a non-profit making company licensed under section 25 of the Act. Hindu undivided family. A Hindu undivided family can have shares in a company in the name of its कर्ता. जो मेन कर्ता होगा हिंदू अनडिवाइडेड फैमिली का उसके नेम पे शेयर्स होंगे. The कर्ता will be a member of the company as his name alone will be entered in the register of members. Insolvent. If any member is declared insolvent, अगर कोई member insolvent declare कर दिया जाता है and he remains a member of the company till his name appears on company's register of the members, और तब भी वो कंपनी का member ही consider किया जाएगा जब तक उसका नाम रजिस्टर ऑफ मेंबर से हटा नहीं दिया जाता. He is entitled to vote in respect of shares held by him, but the dividend on shares will be paid to the official assignee or official receiver. Foreigners. A foreigner may become a shareholder with the general or specified permission of the Reserve Bank of India. Under the Foreigner Exchange Regulations Act 1973. But if he becomes an alien enemy, his rights as a member shall be suspended. Married woman. A married woman is competent to contract and as such can become a member of a company. Trustee. Section 153 of the Act laid down that no notice of trust, express or implied or constructive, shall be entered in the register of members. Therefore, a trustee cannot become a member of a company in his capacity as such, but a trustee can be a member in his own name. Joint holders. The shares of the company may also be held jointly by two or more persons. In a public company, every joint shareholder are counted as separate member, but in private company, joint holders are treated as a single member for purpose of section 3 first third of the Act. The joint holder of shares may get themselves registered in any other they like and may split their joint holdings in a manner so as to enable all of them to attend and vote, unless the article provides modes of becoming a member. First, by subscribing to the memorandum. A signatory to the memorandum automatically becomes a member of the company. On its incorporation, neither application nor allotment of shares is necessary to constitute them member of the company. Even if his name is not entered in the register of members, he will still be treated as a member of the company. Second, by application and allotment of shares. A person who agrees in writing to become the member of the company and whose name is entered in the register of members is also a member of the company. An application for shares is an offer to take shares, and allotment is the acceptance of that offer. The rules regarding offer and acceptance are applicable if a person applied for shares subject to certain conditions. The allotment by the company must be made according to those conditions. Otherwise, the allottee shall not be bound to accept the shares. By transfer of shares, you know that the shares of a public company are freely transferable. A person must buy shares in the open market and get those shares registered in his name. On the registration of transfer of shares, the transferee becomes a member of the company. The transmission of shares. A person may become a member of operation of law, that is by transmission. On the death of a member, his legal representatives have the right to get the shares of the deceased member registered in their names. No instrument of transfer is necessary in this case. By agreeing to take qualification shares, when a director of a public company signs and files with the registrar an undertaking to take and pay for his qualification shares, he is in the same position as subscriber to the memorandum and he is deemed to have become member of the company on incorporation. By estoppel, if the name of a person is improperly placed on the register of members and he knew and assents to it, he will then be estopped from denying that he is a member. Termination of membership. First, transfer of shares. When the transfer his shares to another person and the transfer is duly registered by the company, the name of the transferor is removed from the register of members. Transmission of shares. On the death of a member, his shares get transmitted to his legal representative. Forfeiture of shares. Shares may be forfeited for not payment of calls and other reasons contained in the articles. The membership terminates on share forfeiture. Surrender of shares. When a member validly surrenders his shares to the company, he ceases to be a member. Insolvency of member. When a member is declared insolvent, his share vest in the office receivers or official agencies. The assignee or receiver may sell these shares, and when the transferee name is entered in the register of members, insolvent member ceases to be a member. Winding up of companies. Membership terminates on the winding up of the company, but he continues to be liable as a contributory. Repudiation of contract. If he repudiates the contract to take shares on the ground of misrepresentation or mistake in the prospectus or on the ground of irregular allotment. Enforcement of lien. Redemption of shares. If a member is holding redeemable preference shares, then on their redemption his membership terminates. Issue of share warrants. When share warrants are issued in exchange of fully paid shares, his name is removed from the register of members, although he continues to be a shareholder of the company. Rights of members. Right to receive copies of memorandum and article of association on request and on payment of prescribed fee. Right to receive share certificate within the prescribed period. Right to transfer his shares according to article of association. Right to have his name entered in the register of members. Right to priority to have shares offered in case of increase of capital. Liability of member. First, unlimited company. Every member of such a company is liable for all debts contracted by the company during the period when he was a member. Company limited by guarantee. Every member is liable to contribute to the extent of the amount guaranteed by him, which is given in the liability clause of the memorandum. Company limited by shares. The majority of the companies belonging to this category. In the case of such companies, the liability of a member is limited to the amount unpaid on the shares held by him. If he has paid full amount on shares, his liability is nil. Transfer of shares. Procedure of transfer of shares. First, blank transfer. A blank transfer is an instrument of transfer which is signed by the transferor, wherein the name and other particulars about the transferee are not filled in, and is handed over with the share certificate to the transferee. Second, forged transfer. Any instrument on which the signature of the transferor is forged is called forged instrument of transfer, and the transfer made on the basis of such instrument of transfer is termed forged transfer. A forged transfer deed is legally ineffective and confers no title on the transferee of shares. Distinction between transfer and transmission. Transfer, it is deliberate act of the holder, and transmission, it results by operation of law. Transfer, an instrument of transfer has to be excluded, and transmission, it requires only proof of title of the transferee. Stamp duty is payable on its execution in transfer, and no stamp duty is payable in transmission. Shares are transferred for some consideration in transfer, and in transmission, share pass to another person without any consideration. Company charges for registering a transfer. No charges are levied for registering transmission. Rights of members. First, index of members. Section 151 of the Companies Act requires that every company having more than 50 members shall keep an index of members along with the register. If the register of members is in such form that it can serve the purpose of index, no separate index of members need to be maintained. Second, foreign register of members. A foreign register shall be deemed to be a part of the company's register of members. The company must keep a duplicate of every foreign register. A company of every entry made in the foreign register must be transmitted to the head office in India, which shall record the same in the duplicate register maintained in it. Inspection of register. A company's register of members is a public document and open to public inspection. The register of members and index must be open to inspection by members freely and by any other person on payment of ₹10 for each inspection. The register must remain open for at least 2 business hours each day except when the register is closed under the provision of the Act. The right to inspect also includes the right to make extracts from the register. The company is also bound to supply a copy of register, index, etc. on payment of ₹1 for every 100 words or fractional part thereof required to be copied. Next, closure of register. According to Section 154 of the Act, a company may close the register of members for a period not exceeding 45 days in a year. At one time, the register cannot be closed for more than 30 days. For closing the register, at least 7 days' notice should be given by advertisement in some newspaper circulating in the district in which the registered office of the company is situated. Rectification of register. Section 3rd of Companies Act 1988 provides that if the name of a person is entered without sufficient clause or after having been entered in the register is without sufficient clause omitted therefrom, the aggrieved party may apply to the Company Law Board for rectification of the register. Now there are some questions on the basis of this session. First, what do you mean by the term member of the company? आप क्या समझते हैं member of the company से? What is blank transfer? Blank transfer क्या होती है? Thank you. Happy learning, we learning.